All right, so good morning. Good morning. This is the second iteration of the quarterly supervisor engagement, right? And so I stress again as we start this process, this one's going to be a little different again, right? You're going to get a panel of experts today. So just set expectations. If you look at the bios or the backgrounds on this panel, there's a lot of experience, right? So I won't say they're old, but I'll tell you there's lots of experience that sits at that table. And so for me, there's no the amount of experience and practice on both sides of this service, as civilians and soldiers all over the country with a very impressive set of pedigrees. What I would tell you is wear the panel out, right? Ask the panel the questions, because this is, it's how well you engage today is going to be what you take away from it. And for me, it is one of the hardest changes or differences when you start to deal with Department of Armed Civilians and the leadership inside of that. It's a hard change to one understand. There's a lot of rules. There's a lot of people that get involved, and it's far different than any experience I had in the last couple of decades of doing on the other side. Break. That's no excuse for not doing it, not understanding it right. And so that's really what I charge you with today. As you sit here today, if you walk away from this opportunity without a better understanding of how to be a leader, right? Supervisor, what we call it. For me, it's how to be a leader. And it's not so much, there'll be a lot of discussion, I'm sure, today about corrective behavior. The real goal for me is, hey, how are we developing, right? And so sometimes we get, everyone steps aside, and there has to be some way to correct that. But the real piece is, how are we developing our leaders? How are we developing our team? And I say that because, hey, look, in 30 seconds, I will tell you that the only thing I think that is consistent inside our organization right now is change, right? And so, as we just came off of out of the RIF and out of some personnel changes, what I would tell you, there's more to come, right? So, you may not want to hear it, but that's not my job. I'll tell you, like I said, transparent all the time. I can only tell the truth. There's more change to come. As you look at fiscal year 20 and 21, at least right now, we think there's at least 2.5% of reductions every year for 20 and 21 as we look at our organization. So there is more change to come inside our organization. And when you say change, and what I would tell you is, don't be afraid. And quite honestly, as we look at the change, we get focused on all the things that we are worried we're going to lose, or the impact on us, individually or in our organization. So if we go about the next set of changes, which will always, be out there with the fear that we're losing something, we're missing an opportunity. And so I'll tell you, I sat with the directors yesterday over the last, couple of weeks. There's a real opportunity. I'll just tell you where I see us, as an organization for change, as I get a chance to talk to leaders in this formation. We are about the same structure. We look very similar in terms of positions and structure that we did 10 years ago. 10 years ago, we were twice the size that we are right now. And so as I look at the formation, if we stay like we are, if we don't take this opportunity, and if we don't drive significant change in how we're organized, and make sure that there are people at the action level, not supervisors and managers, we got plenty of those, people at the action level doing tasks, then we are failing as leaders. So the 2.5% over the next 2 years, we are absolutely not going to sit and cherry pick or pluck and diminish what we have in terms of providing resources. We're going to make some significant changes. And so not only are we being directed by change, but I'm going to say we're going to take some opportunity across all the directorates to look at how we improve our organization for change. That's going to create a lot of turmoil, right? That's what I hold you accountable for. That's what I need your help as leaders in this formation to do as we manage change. It's not going away. there is more to come. The Secretary of the Army, and so why? So why all the change? And that's part of your job as leaders to be able to discuss it. I'll tell you what I know, right? So the change, as we've talked about before, as we started the conversation for the RIF, is based on where the Army is going. Right? So the Army has created a new Force Modernization Command. The Army is investing significantly in new equipment, right? So if you are the Chief of Staff of the Secretary of the Army right now, what you see is a large delta between our modernization efforts over the last couple decades and the rest of our peers. And so our Army has to be ready to fight. And so that investment, that change in prioritization for the Army precipitates the change in the organization, because nothing's free. So that, I'll tell you, that piece is not going to change. And then the good news is that this Secretary, over the last 5 months, has issued about 11 directives. And it keeps adding. And those 11 directives include over 30 changes to requirements. Right? So there are 30 things at least that the chief has said we no longer have to do. Trips for weekends. A slew of mandatory classes have gone away, and we started with some of those even inside our organization. So the good news is, I would tell you that, hey, look, as we go about change, it's not necessarily just about reorganizing ourselves to be better, to be more efficient. It's also about figuring out what it is that we need to do. What are our core competencies? What are those critical tasks that we will do as a formation to make sure we're taking care of soldier families, doing our part of this pact that we have here for the big Army, right? So that is it's not going to change. You're going to have a critical role to play, right? And so how you approach it, how well we communicate, how well you understand the reason why, and can explain that, inside your own formations is absolutely important, right? And so as we can kick and scream and hide our corner and hope it doesn't affect us, I'm telling you, it's going to affect every one of us. It affects this organization. And I need your help. We need Sergeant Major and I need your help to make sure that we're doing the absolute best we can for our soldiers and families. And so this is important for me, right? And so as you look at this, I think there's going to be there'll be some consternation going forward. We need to have the absolute best organization. We need to have the best people. We need to, again, this is development. We've got to be able to keep the right people on the right team, doing the right things. And I will tell you there's change for that coming. As before I turn it over to Mr. Allman here to start off, first I'd like, so raise your hand if you've met the new Sergeant Major yet. All right, so Sergeant Major, come on up here. Hey, so I get a chance to introduce Sergeant Major Rebecca Myers, who has been here before. If you haven't met her, so there she is right there. And so Sergeant Major comes from us with a dog command Sergeant Major, a wealth of experience and knowledge, right? So I would tell you, she gets out about in the battle space. Please engage Command Sergeant Major, an MP. So she's going to tase Ed when we're done here. But an MP who has served at Fort Stewart before with a tremendous amount of experience. You want to say something, Major?
Hey, just thank you everybody for your patience as I'm coming on board and I'm making my way around. So just look forward to getting out and meeting each and every one of you and working with you. So if there's anything I can do, please let me know.
Thanks, Sergeant Major. All right, hey, so before we get started with the official portion of this, any questions, complaints, gripes, concerns before we get started? Ed. All right, okay, good. Mr. Allman, sir.
Morning, everybody. My name's Tom Ullman. I'm the Director for Human Resources, and I'm going to kind of give you a little bit of a, can you go to the next slide? See, you're supposed to be the flipper. Okay. All right, this is the purpose, to talk to you as leaders about civilian disciplinary procedures that we utilize here at Fort Stewart and Hunter Army Airfield. And it's interesting because, the Colonel just talked about change. In 2012, that's when we changed to the current process that we're under. And I've been doing the DDO stuff since 2012, which, who knows what a DDO is? Anybody? One person? All right, how many people from DPTMS here? Put your hand up. All right, you guys all ought to know because I briefed you all. The same slide, right? These slides. So I'm not going to apologize to you because I heard at an employee engagement conference in March of last year that nothing sinks in until it's been repeated to you 13 times, okay? So you guys, this is number 2 for you. Everybody else, you got 12 more times that you got to go through this presentation before it's going to sink in. Now, I'm just kidding. I'm not kidding about 13. They actually, some doctor told us that. So anyhow, next slide. All right, this is what I'm going to talk about. I'm going to talk about the process. I'm going to talk about you as leaders, the preparations, you know, on your decision for the disciplinary actions, some of the supporting documentation, and I apologize on my initial introduction. I do the deciding official duties for the appropriated fund employees. Mr. Tafoya does the deciding official duties for all the non-appropriated fund employees, okay? And I had the fortunate opportunity to do that for the non-appropriated fund employees when I started, and now I guess I wasn't doing very well, so they gave me the appropriated fund employees to do that. So anyhow, after that, then we're going to talk a little bit about, you know, what Ernie and I do. Then I'm going to talk just briefly, I'm going to talk about Douglas factors. Douglas factors are very important, and I highly encourage you, if you haven't, I sat through a presentation by our great SJA team, Miss Tammy and Miss Nicole, and they are the experts. So if you got any of the legal stuff and when your preparation on charges and you know, ask when they come up here. Okay, don't ask me that stuff. All right, those kinds of decisions have already occurred by the time your packets come to me. Okay, and then we'll have the panel. All right, next slide. All right, so this is kind of the process. First of all, an incident occurs. Okay, somebody does something bad. Right. As a leader, first thing you want to do, gather all the facts. Typically, you want to meet with the employee. I mean, I do. I ask them a little bit. You got to be careful because you get into the Weinberger and you got to make sure that they get union representation, you know, if they think a charge is going to come and your employees have that opportunity. Then you consult with your senior leader. A lot of times, you know, some of these things will go to CPAC and they may not have gone through the director. I highly encourage, I mean, they've got a little bit more experience under their belt than you may have as the direct line supervisor. So please consult with your senior leader in regard to any kind of proposed disciplinary action before you just launch off and go see Mr. Riccaccio, okay? And then, yeah, right, then after that, after you've assessed it a little bit, maybe there's a serious nature of the offense, and you may need to do a 15-6 investigation where you would go to the colonel and request that or commander's inquiry. Or you can actually do an internal inquiry, you know, within your own directorate. And I've done those in the past just to get some of the facts up, all right? Then after you review the incident, you'll look at the table of penalties. I'll talk a little bit about that later. Then you'll consult with the senior leader again. And then you go with your proposed punishment, you know, to Mr. Riccaccio. He'll take that, he'll assess that with SJA's guidance, and then the proposal, after it's coordinated there, then that proposal with the punishment, you'll call in your employee and you'll read them your proposal for the punishment and whatever the alleged offense is. All right? That's what you'll do. And then, next slide. Then it comes to Mr. Tafoya and I. We received the packet, and the packet's got all the evidence that you've provided. And I'll show you a list of some of the things that I personally look for, and I know Mr. Tafoya also looks for in those packets. It's really gathering all the data and all the facts in regard to the employee, right? Then I will, and I do this, you know, when you write out your proposed punishment in your notice to the employee, I think it's 7 days that is provided to them to make an appointment with the DDO. Well, as soon as I get the packet from Mr. Roccaccio, usually I reach out because I want to see that employee. I want to see him face to face. I want to hear what they've got to say and allow them to provide any information to me before going forward and reviewing the Douglas factors to make a decision on that. So I usually meet, I think 99% of the 55 cases since I've been doing that, I've met with the employee. So maybe once or twice. And you know, they don't have to meet with the DDO, but it behooves them to meet with the DDO, okay? Then I do, after I've met, I take their information, I do a memorandum for record on our conversation. I send that memorandum for record to the employee and to their director and to CPAC, okay? And then I take all the information and I review the Douglas factors. And I'll talk about those 12 Douglas factors briefly. After I review those, then I make a decision on what I'm going to do. Either I'm going to say, there's no real fault here, there was some other reason, or really, I'm just going to throw it out. The other thing I'm going to do is I can mitigate the proposed penalty. I can say, okay, you're requesting 3 days. I don't think it's really 3 days. I think it ought to be 1 day or 2 days because you didn't maybe do progressive punishment in your action, okay? And the third day, the other thing I can also do is I can enact the punishment and I can give a last chance agreement to the employee, okay? And in my view, my personal view on a last chance agreement, you know, in my opinion, anybody can hold their breath for 1 year, okay? I think anybody can hold their breath for 1 year. They can't hold their breath for 2 years. So if I'm giving a last chance agreement to an employee, I'll give them a last chance agreement for 2 years typically, okay? That means if that employee, you know, they're guilty, but there was other mitigating circumstances, whatever, so I'm going to give them a last chance agreement, you know, to actually, you know, be a better employee for those 2 years. And actually the punishment, and when you're given punishment, that's supposed to improve the employee, okay? It's to make them a better person, unless it's a separation, of course, all right? Then after, let's see, then the decision notice goes to CPAC. CPAC sends it to SJA to make sure it's, everything's legal. That then draft decision notice comes back to me. I call the employee in, set them down. Usually they've got some representative with them, usually the union. Usually they don't pay for an attorney up front. And I issue them the notice, and I tell them that they have the opportunity to file EEO or to grieve or appeal the actual decision. Okay? Next slide. Okay, table of penalties. There are two different, these are the regulations. The first one is for appropriated fund. And this one's kind of hard to get to. You know, if you go on the U.S. pubs, it takes you to a website to find this table of penalties, but it's out there. If you need it, I can send you the table of penalties to review. But the table of penalties for both AF and NAF, that is only a guide to discipline. That's not a hard and fast decision. And it actually shows you first offense, these are the penalties. Second offense, et cetera, right? And that's the next thing, progressive discipline, okay? And I mentioned that before. You want to use progressive discipline. Progressive discipline means, okay, you don't want to separate someone right off the bat, okay? You want to use progressive discipline. And I think a misnomer that a lot of leaders have is they think that a counseling statement is discipline. A counseling statement is not discipline, okay? So when you're reviewing, when I'm reviewing the Douglas factors on prior disciplinary actions, someone thinks that that's prior disciplinary action. That's not a disciplinary action. That's counseling, okay? Now, a letter of reprimand, that's disciplinary action. That's basically the lowest level of disciplinary action you can take. Okay, and then there's two separate categories in regard to penalties. Number one is 14 days or less, okay? And the difference between these two, I'm leaving that up to our legal counsels to talk about it. The second category, next slide, is 14 days or more or removal. And, from my layman's review of this, one of the key things is the timeline that is provided in these two different categories. You guys can answer that question when you get up here. Okay, next slide. Okay, this is the kinds of minimum supporting documentation that both I and Mr. Tafoya are looking for when we receive the packet. Okay? First, any supporting investigations. There may not be a supporting investigation, but if there is one, that. Previous disciplinary action. Okay? Disciplinary action. All right? You know what disciplinary action is. The last 3 performance evaluations of that employee. How good of an employee is that person? Have they been doing their job successfully? And how have you been rating them? Their start date of federal service, how long have they been in service? Start date of their assignment to your organization. They may have been in federal service for 20 years, but they may only been with you for a year or so, okay? And you may have different rules and requirements that they may not be familiar with, and that might be what you're charging them with. So there might be other mitigating factors there in regard to the charge that you're proposing. And then the method of the incident notification and management. In other words, if they did something, did they come to a leader and tell them that they did something wrong? Okay? And then the last, performance counseling statements. And why do you think I'm asking that? All right? Are you coaching, teaching, mentoring that employee? Okay? And if that's not in there, and now we're in the DP maps. We're supposed to be doing counseling every quarter. I don't think with DP maps, I think it's like 3 times, okay? But, our policy is that we want to counsel on a quarterly basis. All right, next slide. Okay, the DDO, Mr. Tafoya and I, are impartial people. So if I have a disciplinary action for a person in DHR, I'm not the DDO for those decisions. All right, I'll make the proposal. It'll go, one of my supervisors will propose some type of punishment for an employee for some type of disciplinary action. It'll come up through me. It'll go through that process I've talked through, and then it goes to the DDO, not me. It'll go to Mr. Tafoya. Likewise, if it's one of the persons that Mr. Tafoya rates, it'll come up through me. Yeah, and this is what I do in the assessment. I review all the evidence that you have provided, and this is a question that a lot of managers ask, okay? And this goes back to the duties of the DDO. How come I can't come talk to the DDO as the manager? Typically, if you're proposing a punishment, I do not want to speak to the management at all, okay? I'm supposed to be unbiased, but I'm a manager, okay? And the main way to be unbiased is not to hear anything from what the management's got. So that's why you got to have your ducks in order with the packet and all the information that you provide up front to me, all right, and to Mr. Tafoya, because we got to remain impartial. We're the judge, basically, okay? So we want to make sure that we remain impartial, so that's why we don't want to really speak to management. And then another question is the employee's health question. And that's one of, actually, when you go into the Douglas factors, and I'll tell you what, when I assess a lot of that in my face-to-face with the employee. That's where I'm assessing, are they under any other stressors out there that would maybe make them do that would be transparent? Because remember, your employees, if they have health concerns or they have certain issues, they don't have to share that stuff with you. Okay, but a lot of times, in those face-to-face sessions that you have with them, you can sense, or they'll tell you about, well, I'm under all this stress, and then you can kind of figure out, if you're looking through the counseling, you're looking through all of the data that you all have provided to assess that. Some guys, some people are very good at telling stories, if you know what I mean, all right? And sometimes they'll pull the wool over your eyes. And it's kind of like the thing with, when you're going to do a last chance agreement, that's what I said. They can pull the wool over your eyes maybe once, fool me once, but don't fool me twice, all right? So that's why, when you do a last chance agreement, I try to make sure I do that for 2 years. So. Okay, next slide. Okay, then the DDO process. These are some of the considerations. Is the decision arbitrary? Did management have a good cause for it? Was the action reasonable? Was the action an abuse of discretion? Now that's you all right? I'm assessing you as the manager on that. And then my decision will be based on the Douglas factor assessment, and those are the three things: sustain, mitigate, or cancel the action, okay? Now, sustain, that's if I am, I kind of misspoke earlier. When I'm doing the last chance agreement, typically that's when I'm sustaining the action, okay? And I've done that about 4 times, and all of them have been, I believe, due to separations, okay? All right, next slide. Okay, now the Douglas factors. The Douglas factors, where did that come from? All right, it came through a case. I'm sure that these ladies are much well-versed than I am on case law, but it was a case of 7 employees. It was Mr. Douglas against the Veterans Administration. And after that case, there was an assessment by the Merit System Protection Board in regard to punishment. And they reviewed the case, and they decided that there needs to be some type of criteria that should be assessed in regard to the punishment and decisions on punishment toward separate employees. In this case itself, as you can see down in the bottom there, out of the 7 individuals, no, it's up front, out of the 7 employees that were a part of this case, 5 of their punishments were sustained, and they were actually removed from their position, okay? But this is basically the background and a little bit of the history on the Douglas factors. Next. This is the reason that we do the Douglas factors. I'm not going to read that to you. I'll let you read through it. Now, each of these Douglas factors, when I look at them, and you need to look at them too, when you're making your decisions on punishment up front. But please, please do not give Mr. Tafoya or myself a copy of your Douglas factor review, because I don't want any undue influence on us in making our decisions. We'll go through the same process that you are doing, but don't send them to me, okay? Because I don't want to be unduly influenced. And when I go through the factors, I'll look at them and I'll say, is this aggravating? Okay? Is this neutral, which has no impact, so it's kind of a null and void thing? Or is it mitigating and something that I should maybe lessens the punishment that I'm providing or recommending or that you're recommending on the employee or not? So those are the 3 things that I'll make on each, or decisions that I'll make on each one of those Douglas factors. All right, next slide. These are the Douglas factors. The first one, I would say the first one is the most important, okay? And that's really determining the seriousness of the offense, okay? And when you're thinking about that one, and you're going through the process of this one, this particular Douglas factor is the one where you figure out, and you're using the table of pennies, and you're figuring out, okay, so, how bad is this actual offense upon the good order and discipline of my organization? That's the bottom line, okay? The next one talks about, the level of employment, type of employment. The next one is that past disciplinary action. Is this his first offense, second offense, third offense? The next one talks about their past work record, okay, length of service. Typically, that one is mitigating. The more time an individual has, typically that's a mitigating factor. The less, maybe not. Next one is the effect of the offense on the employee's ability to perform, okay? The next is the consistency of the penalty. Now, basically, what I do is I look through, I keep a matrix of all of the disciplinary actions that I've taken across the last 6 years. and I look at what the offenses were, and then what penalties were proposed, and then what penalties that I imposed upon the employee. So am I being consistent in my distribution of penalty across my time as the deciding official? Next. The next one is you look at the table of penalties, and is it consistent? Now, sometimes it's a little bit difficult because I know it is for me, I don't know about it for Mr. Tafoya, but I'll look at the table of penalties, and I'll look at what you're proposing, and that may not even be in the table of penalties, so I got to kind of figure out, okay, is this, what are you actually charging them with? And I'm trying to make sure I do that linkage to make sure that that I understand it. And then is it consistent with the proposal that they've got in the table of penalties? Now remember, that is just a guide. The table of penalties is just a guide that we use, but that's where I do that assessment. And then the clarity of the employees, were they on notice of the rules? And that's kind of where I go back, and I actually look at those counseling statements, and I look at, you know, how long the employee's been in there, and if they're an employee that, or if your procedures and the documentations that you've provided are really clear. Sometimes I've seen something that may be in a reg hidden somewhere, and you're charging them with something where they violated that reg that, you know, how's that person supposed to know about that that's the way they're supposed to do business? You know, is it briefed to them? Do they have a clear understanding of the rules? Kind of like for me, let me give you an example in DHR, one of the things that I do, okay? Every quarter, we have an all-hands, okay? Every quarter, I go through every policy letter. I don't read every one of them, but I go through every policy letter, and my employees can attest to this, and our SOPs. So if there's anybody that has any questions on what those are, and if they're going to violate them, then, you know, really I'm taking away that excuse for the employee. Okay, so they can't say, well, I didn't know, all right? So I encourage you as supervisors, if you have particular policies or procedures that you have, that you make sure that your employees clearly understand what those policies and procedures are, okay? Because otherwise, if I'm looking through all the data there and I'm saying, well, how would they know this, that this is even an offense, okay? So that's one of the things that I review when I go through that. The next one is the potential for the employee rehabilitation. That's kind of key too. You know, you want to, and a lot of this stuff, that's why I think it behooves the employee to come and see the DDO. Now remember, all of us as leaders, you know, we don't want to kick people out. We want to rehabilitate, and we want those people to be better, productive employees to help support service members. That's our job as leaders, okay? So that's what we want to do. So when I do the face-to-face with the employee, that's where I get a lot more feel for whether that person is really going to be able to be rehabilitated or not, okay? And then any other, now this is key too, is there any other mitigating circumstances that should be considered, all right, or that should be considered as a part of this? You know, sometimes there are other factors in there that aren't addressed in the other Douglas factors that maybe I glean from, you know, one of the statements that you had in there, or maybe I glean from my face-to-face interview with the employee, and then that will be assessed in that point. And then the last one, is there any other thing that could be done in regard to that particular charge or proposal that you're providing, and then how should that be assessed? Okay, next slide. That's it.
Don't ask any questions.
Panel.
Save them. All right, everybody, go ahead and have a seat. I'm going to put those other slides up.
Is there any coming up? Want to pull another seat up?
I did not think Mr. Tafoya was going to be here today. So I did not have a seat for him. By golly, I remembered to print out a card. So there we go.
I want to listen to Tom.
Yeah, the problem is-
Before we get into the questions, so I do the DDO decisions for non-appropriated fund, where Tom has Paul Richaccio, I have Sue Faust. Sue Faust is in charge of CPAC, but I have the assistance of the same lawyers. So that's what the kind of the difference is when they're dealing with NAF across the board. But otherwise, I follow the same Douglas factors. I follow the same procedures. I've had a couple of folks that have asked the union to either say something in their behalf, or in one case, a lawyer. And so dealing with the lawyer was a great experience, and going back and forth to determine the decision. However, I did not allow his opinion to influence my decision. I just was looking at the facts. And once I brought him on board with the facts, then actually he came over to my side. All right.
So, this is Mr. Almond's bio. You guys have all met him. Do you want to introduce yourself, sir, or do you feel like you've done enough?
I've done enough.
Okay. So now, normally I would be followed by Mr. Tafoya's bio, but like I said, I did not know he was going to be here today, so I don't have his bio, hopefully. I sent the slides out to everyone ahead of time. You've all had an opportunity to read it. So, Mr. Tafoya, you just introduced yourself, and I appreciate that. So now I will move on to Ms. Price, who is the Chief of Civil Law. Can you do a brief intro?
Sure. My name is Nicole Price. I'm with the Office of Staff Judge Advocate. I joined this installation in March by way of VA. So if you've paid attention to the news at all the last 4 years, VA has had a very heavy emphasis on accountability and employee accountability. Just like the installation here, there's been a lot of changes. There was a lot of resource shortages and a lot of restructuring to find efficiencies. A lot of the principles are the same. I find this to be a very gratifying line of work. A lot of hands-on and real-time kind of results. And I think it's important and it's an honor to be a federal employee. I think in the news a lot, federal employees get kicked around, perhaps unfairly. Some of the federal employees that I've seen have been the hardest working, individuals. They blood, sweat, and tears. And I don't know that they get enough credit for that. But I think when you're trying to do the right thing, and a lot of these principles can be frustrating because they're unknown. But once you know the framework and you know what you're working with, we throw around words like the Douglas factors. All that is, as Mr. Allman explained, was a list of things like a checklist that we go through to determine whether a penalty is reasonable. All it is a guide to go through and frame that thinking as to whether removal is an appropriate penalty, whether a 30-day suspension, whether it's proportionate, how serious is it. It's just a thing to walk you through that thought process. It's not scary. Words like due process. All due process is the notice to the employee. If you're being fired, you want to know why. You want to know what evidence is being used against you. So all due process is, if you ever hear that, it's notice to the employee, both of what they did and what the evidence is, the opportunity to be heard, the opportunity to say your side of the story to the deciding official, and then the idea that the deciding official has to be open-minded enough to be an impartial decision maker. So we'll get into that a little bit more in our Q&A. But so that's basically, I think it's very important to understand these factors and as we're doing these jobs and leading our mission forward.
Okay, and then our next panel member is Ms. Gerhardt, and she is the Labor and Employment Attorney.
Good morning, I'm Tammy Gerhardt. I've been here at this installation since April, mid-April. I came from the Corps of Engineers. So it is United States Army Corps of Engineers, so the principles are the same, which is wonderful. I was at the Corps for 9 years. Majority of my time was the Corps. I was a labor counselor, And I just wanted to say I'm grateful and honored to be here and serve you all.
Okay, and then the last member of the panel today is Mr. Paul Ricaccio, who is our Labor Management and Employee Relations Specialist with the Civilian Personnel Office.
Good morning, everyone. I've been here since 1976 with the military, and I got out of the military in 1979 and started with the civil service in 1980. And I've been working with the CPO back then, and now it's the CPAC, as in different phases of the personnel office. And I've lately been serving as the Labor Management Employee Relations Specialist. We have 3 of us there at the CPAC that you can call upon for assistance. And we're there. You can go ahead and next slide. And I've been advising managers for the time that I've been here on disciplinary actions. And believe it or not, you have a lot of authority at your fingertips to discipline your employee. Now, even counseling is considered as discipline. Now if you're looking at a table of penalties and you're counting the offenses, first offense, second offense, you wouldn't count the informal actions that you take, like warnings and counselings, as an offense. But that is used to correct your employees' behavior. And that's the bottom line. You want to correct their behavior so that they're in line with what your operation is all about. And so the next slide here shows you what the formal offenses are and the informal offenses. Now our informal range of options that you have, you can take these informal on your own. Now, anything that you would like us to review with you, like warnings and counseling, we'll certainly do that with you. But now whenever you go to the formal actions on the right-hand side, we do need to be involved. So please give us a call whenever you're wanting to take any of those actions. And most of those letters are reviewed by the legal office before you're allowed to issue those.
Okay, so these are the 3 MER and labor advisors that you can reach out to. And what I'm going to do now is open the floor to questions with one provision. If you're going to ask a question, be careful that you are not too specific. You want to make sure that your questions are general. If there's a specific situation that you want to discuss with one of the panel members, save it for later. This is general inquiries, so you can better understand the process and better do the supervisory actions that you are trying to do. So with that, I will open it up to the panel, and folks, just go ahead and ask questions. I ask you to speak up so that everybody can hear you.
Yes, sir.
When you mentioned last chance agreement, in layman's terms, you call that a 2-year probation?
Pardon me?
Would you call that in layman's terms like a 2-year probationary period?
Yeah, I would say so. The key thing there is, though, the individual has been found, they've been found guilty of whatever the charge is. Now, the other thing that I didn't mention, on a last chance agreement, you can also, impose some type of punishment. For example, your recommendation as a supervisor may be separation, okay? So you put in there and you want to separate the employee. I could say, I'm going to give you 30 days suspension, and then do a last chance agreement for the actual proposal of separation for 2 years. So, I mean, that is also within the realm of something that Mr. Tafoya and I can do.
Right.
But typically, a last chance agreement means that, they're found guilty of whatever you're charging them for as a part, as the supervisor.
So is the last chance agreement, last chance based on that disciplinary action, or you say last chance anything?
But so, actually, if you give a last chance agreement, you don't have to, you can do anything during that 2-year period. If it's a disciplinary offense, and then boom, you're gone. Okay, so, and actually that employee waives rights. They have to sign, it's a very lengthy document that they have to sign. They're waiving rights when they sign a last chance agreement, which means that they can't grieve, I believe, and a couple other, I'll defer to our legal team here, but there are certain rights that employee waives when they sign a last chance agreement.
And now, something that's important to understand in terms of the mechanics of this, an agreement, it's a bilateral agreement. Now, if you're facing a removal and you're being given the option to have another 2 years, and in exchange for that, what happens is it's a bilateral agreement. The employee is agreeing to this idea that, hey, give me another chance, I can be on my best behavior for 2 years. The terms of that agreement govern what is going to be considered a breach of that last chance agreement in the future. Usually we make it very broad in terms of what the misconduct is. It could be defined narrowly, but the individual terms of that contract, it's a settlement agreement essentially. You're waiving your rights to appeal, you're waiving your rights to future litigation on the removal that's at issue. So what's actually happening is you're holding the removal in abeyance, and if the employee commits an infraction that's defined within the terms of the last chance agreement, that removal comes back with full force and effect, and that's something they cannot grieve or appeal. What they can appeal is whether they breached the agreement, but that's a more limited inquiry, and either they breached it or they didn't, and you don't have the same level of rigor that's conducted by the MSPB in reviewing that action.
So like suspended sentence on the civil law and the military, be suspended punishment?
Basically, you're holding it back. You're saying, but it's something you're not bluffing, okay? So the deciding official has said, hey, a removal is warranted here, but maybe there's a glimmer of hope in terms of rehabilitation potential. A true second chance. But I really agree with this idea of anyone can hold your breath for 12 months. So if someone for 2 years is able to straighten up and fly right and they don't commit any more infractions, well, that's what we want. We don't want to have to go through the process of recruiting and training and building up. We want a healthy, productive workforce. If we're able to save someone via a last chance agreement, that's a victory. So it's a really great tool.
I have a question, and I guess maybe Paul may be the one. On that table, you had an informal letter of warning as a step versus under a formal letter of reprimand. How do you decide which is which on those two things?
Did everybody hear that?
Yeah,
Okay.
okay.
On the slide there, you had informal and formal options that you had. So all of those that are informal, like counselings and warnings, are not considered as the first offense. They are not considered. So you can give your employee warnings and counselings, but whenever you go to the table of penalties to correct their behavior using formal offenses, you don't count those informal. You only count the offense that you're using to correct them using a formal offense. So that would be the first formal offense. So that you may have had 3 or 4 counseling and warnings prior to eventually giving them a reprimand. And so the reprimand would be the first offense, first formal offense that you would use in counting on the table of penalties.
And also to add to that, I don't know if part of the question was also like how to decide which one to use. I'd say that's probably managerial discretion. The agency doesn't have to take the least action possible, but it's definitely preferable. So if you think that counseling will correct it, there's several tools that managers have in a toolbox, and they can all be used. So counseling, coaching an employee, if you think that will be sufficient, an employee will say, oh my goodness, I am so sorry, I had no idea I was screwing up, I will never do this again, let's go for that instead of the formal. And also depends how many priors they've had. If it, like counseling hasn't worked in the past, then maybe it is time for a reprimand, maybe it is time for a suspension. So I don't know.
The severity of misconduct is key as well. in terms of whether you go formal or not, because it matters whether it's going into their formal OPF or whether it's just going to be a local level thing.
Yes, we have
And
two.
that was the question I had as far as, so a warning letter just goes in my local file, whereas a reprimand, which is formal punishment, would end up in their
OPF.
OPF.
Temporary, it was reprimands. One thing to keep in mind too, there's two things. Now, yes, sir, I see you totally, I'm so sorry. So with reprimand, it can be a 1-year reprimand, it can be a 2-year reprimand, it can be 5. I don't know how far we can go, Paul, with that. So whatever the manager decides, that's how long it stays in the OPF. Then MER or whoever's in charge will pull that after, if nothing else happened and then it's time to pull, then it will be pulled. One thing to consider too is progressive discipline is not to use expired discipline. Like for instance, if the employee had a letter of reprimand, but it expired, it was pulled back from EOPF, like it's done, then it cannot be considered prior discipline.
Usually that's something that's the duration of these various disciplinary actions will be covered in the collective bargaining agreement. So it might be a reprimand for 2 years or whatnot, and then those kind of, they've served their purpose and they get taken out.
Yes, sir.
My question is kind of in line with what they were talking about. Okay, we went to the informal, we decided to go ahead and take as a leader, assist that employee. Now you decide to take an informal route. How long before we just go? Is it like 1 or 2 counseling that can be done to assist the employee? And let's say we actually gave them a letter of reprimand or whatever. Can we use that letter of reprimand and those counselings in the past saying that this is something that she's going to pass? Use that too.
Absolutely. So the idea too with, even if you pulled something, you might not be able to use it for purposes of progressive discipline, but you can use it for purposes of notice that the employee knows that this kind of conduct is inappropriate or won't be tolerated. So
If it relates to it also, it all depends. I think it's so situational.
I think where I was going.
I'm sorry.
I lost my
That's like-
train of thought.
But I think
One
that's
thing
like the
that,
Douglas factor.
one thing, it does go into the Douglas factors, but one thing that people think that you have to be locked into this rigid idea of what progressive discipline means. And if you've got someone who goes and stabs somebody on their, in the middle of their shift, testing.
No.
So, okay, so if somebody goes and stabs their coworker, obviously you're not going to start at a reprimand and start going through progressive discipline. So it is proportionate, and that's where we go back to this factors test of progressive discipline. Now, if it's the first time they've been late and they're 15 minutes, do you go straight to a removal? No, you don't. But it's kind of like the idea of proportionate progressive discipline. The entire point of progressive discipline is supposed to be a slap on the wrist so that the employee feels the sting and knows that that's not okay, and they change the behavior. That's the entire point. Now, you don't have to be locked into always starting at a reprimand. If it's bad, you can start off at a 5-day. You can start off at a 14-day, but that's where we're looking at what our factors are in terms of what the person's job is, what the seriousness of the misconduct, how long have they been in federal service, all of these things. So it really is a case-by-case basis.
Just a caveat on the, not the formal discipline, but the informal. I mean, that's why I asked to make sure I'm looking at your counselings. You may have counseled that person. That's not a formal discipline, but that's something I'm looking at. Did that person understand? And you may have counseled them. Hey, you're late for work. I don't want you. And you counseled them again. You were continually. And then all of a sudden you get this. Well, I know that you have actually taken action as a supervisor to make sure they're on notice, they know, and then they just jacked up. They went too far. So that helps for me to sustain whatever your proposal is when you're actually going for the disciplinary action.
And in this vein too, I'm going to pile on and then we'll go here, but the idea that we tend to avoid conflict in our performance ratings. And if you've got someone with an outstanding performance rating for 3 years And then you come in and they say, oh, they're really just a mediocre employee and their customer service skills have been going downhill and we've received all these complaints. What we'll control to a third party is going to be their formal rating of record. So if you can give someone a rating and you can have a mix of positive and areas for improvement. You can use the most dancey, flowery language you want to use, but if it's not in there and you avoid that conflict or avoid that issue, all you're going to have in there is a flowery, wonderful, this is a beautiful employee and we love working with them. And that's not going to help your case as to why discipline is reasonable for this employee.
Bruce?
Ma'am, what did you say first on your response to him? We didn't hear.
I'm so sorry. Basically, the idea was you don't want to get locked into the concept of that you have to start at the lowest level possible and that it's proportionate to the circumstances. So I don't remember exactly what came out of my mouth, which is why we can roll the tape. I'm sorry.
Did I promise?
But it's the idea that it depends on the case.
So when it comes to counseling, this is another pile-on. It seems like we're piling on the one question. We've heard it before. If you don't show progressive counseling to prevent or correct misconduct, that doesn't verify or validate the charge, so to speak. So you're saying a flowery evaluation, but if you have no counseling from that evaluation forward, whether it be MFR or written verbal counseling or anything like that, those things the DDO and yourselves look for is that, okay, yeah, you're doing good, but here's a turnaround. And the supervisor has, whether it's been informal, 3 informal counseling, you've been late for 15 minutes in the past quarter. You need to change it. Next time, again, progressive counseling going towards,
that's the documentation. So now if you were going back and saying, well, from the previous year, they were always late, but then you don't address it, or they haven't been, and something that's important too is performance is going to be different than misconduct. So if you're talking about performance versus if you're talking about true misconduct, like being late is generally misconduct.
And also one thing to add, and I think that's an important overarching concept between the two, there are absolutely different routes, performance and misconduct. The overarching concept is addressing, and I think they brought that up, is addressing issues as they occur. So, and also what Nicole brought up is not holding back, because sometimes what happens is, like, we don't want to, like, we're all human, we don't want to have conflict. So we're like, well, I want to address this one, it's really getting under my skin, but not going to say anything because I don't really want to engage with this employee. Then they do something again, and they're really disrespectful, and they're getting under our skin even more, and then just, they're out of control, and we didn't do anything, and then they do something minor. And we forgave them those 3, or we didn't do anything, and then on that minor, we were ready to slam them. But then there's no documentation that they've been doing all this other stuff. So then it's going to look really bad, and the decision maker, the impartial decision maker, especially if it goes to the court, the judge is going to look at it and say, let's see, so they were just like 15 minutes late, and you're punishing them in this way? How come, agency? And then it probably won't be sustained. So it's very, very important, as I think many of us have pointed out, to just continue to keep in mind to address things as they occur. So if there is misconduct and it's slight, let's go ahead and address it head on, say just don't do this again, and progressively and proportionately, and there'll be proper handling of the matter that will help us down the road.
I'm trying to avoid a straw that broke the camel's back situation.
This has been good because even though it's not the same topic, you brought it up that performance evaluation is not the same as a misconduct counseling.
Right.
They can have misconduct but still be an outstanding performer, but it has to be documented.
And the performance will be one of those Douglas factors. Is this an outstanding employee who goes above and beyond and really contributes to the work unit? And that can weigh in their favor.
Sophia?
Question?
No. Okay.
You good? So a different dynamic for the non-appropriated funds employees. I will tell you that the child development centers, everything is documented. Every counseling session is documented. And so they go ahead and they have an employee folder, and they'll go ahead and do this. Then I get the added advantage, I get video in all the CDCs. So I'm actually be able to look at the video, and then I have to look at it and then try to determine what the supervisor said, what the employee did, and whether or not the act was either accidental, malicious, or they were untrained. And so I have to go ahead and look at that dynamic. In most of our non-appropriated fund facilities, there are video cameras. So it's an opportunity to do that. So I have to go one step above that particular piece to make sure that I've got it. So that's the difference whenever we're doing this. And if you go to the non-appropriated fund folks, they have the best training records available, all right? Onboarding, don't matter, it's all there. But whenever the employee decides, it says, I'm not trained, then I can go ahead and just like Tom does, goes back and looks, doesn't want an opinion, but wants the record that that person was trained or not as we go ahead and make the decision. So that's kind of a dynamic that we go ahead and do that. So then I, in turn, work with Sue Faust and whether or not that particular penalty is deserving of the action. And so I go back and forth. And a lot of times, sometimes it's max penalty. It might be a 5-day suspension for second offense versus a 3-day suspension for a first offense. And so we can go ahead and look at that particular piece and do that. And sometimes the union will go ahead and weigh in. And that's, they're looking at, can the employee afford to have that loss? What's the impact on it? And those type of things. And so those are just mitigating factors that go ahead and look at the whole person concept.
Okay, thank you. So I want everybody to say thank you to our panel. That's the end of our hour. And before I introduce Mr. Stewart, the Deputy Garrison Commander for Fort Stewart, to close this out, I want to remind everyone, if you did not sign in when you came in, make sure you sign in when you leave. Mr. Stewart?
I'll be like a Baptist preacher. Breathe blank God. First off, again, thank you all for this. It was very informative. I certainly learned something every time I hear any one of you speak. The reason you do discipline for employees is to, number one, as Paul said, is to, number one, to make the employee a better employee. And you also do discipline because it's the right thing for the organization. That's kind of what our labor attorney alluded to. If an employee is not doing what he or she is supposed to be doing, whether that's performance or behavioral, it affects the job unit. And so really, that's the reason we do that. As you can see, we've got an experienced and highly skilled employee labor team here. And my advice to you is, and I'll tell you I do this frequently, call on them. And if you have an issue, call Paul. He can advise you from the employee relations standpoint. When you get into the technicalities of how to charge and things like that, call on Tammy and Nicole, because that's what they're there for. Again, it's about increasing or enhancing the performance of the employees and protecting the unit. So thank you all very much, and everybody have a great day. Have a good day.